All right, everyone, welcome to today's webinar, GDPR 101, What You Need to Know. Our presenter today is Gary Glover, who is the Vice President of Assessments at SecurityMetrics, and he has about 13 years of experience in the PCI audit realm. So we're happy to have him presenting today. And just one more quick reminder here, we will be sending out a recording of this presentation for your review.
Okay, thanks very much, everybody. We appreciate your time today, and hopefully it'll be worthwhile. Again, this is kind of just an introduction to GDPR. Most of the industry is still kind of waiting to find out more about it and what happens and how things are going to be interpreted. We'll talk a little bit more about that as we go on, but our audience today really are people who are in the EU or anybody processing personal information data for subjects that live in the EU. So it could be American companies, it could be companies from other countries all over the world. So the GDPR applies to those organizations located within the EU and outside if they handle data of those within the EU. So that's just want to make sure that we're clear on that. So following the GDPR guidelines then will be very important for those people, for those companies. So let's talk about what we're going to do today. We're going to talk just about how GDPR compliance impacts you, your company. We're going to talk a little about clarifying some of the GDPR requirements as much as we can at this time. Again, as time goes on, continue to be watching for further information from SecurityMetrics and other security providers as they learn about GDPR and how it's being interpreted, etc. We're also going to talk about just kind of some data security best practices. One part of the GDPR essentially just says do good data security. So we'll talk about what we feel that means as being in the security industry. As mentioned, I've been in the security industry for about 13 years now. SecurityMetrics has been around since that time. We've been working heavily in the payment card industry as well as the healthcare industry here in the United States for companies all over the world. So let's get right on to it then. Just starting off, we're going to get into some basics. So what is the GDPR? The General Data Protection Regulation replaces the EU's Data Protection Directive. It's got some numbers after it, 9546 EC, and it was really designed to harmonize data privacy laws across Europe and to protect and empower all EU citizens' data privacy and reshape the way organizations across the region approach data privacy. So that's kind of a statement that we found, an official statement on that. Different countries did slightly different things for data protection throughout the EU, and this is supposed to unite them under one regulation to rule them all. So after 4 years of preparation and debate, the General Data Protection Regulation was finally approved by EU Parliament on April 14th, 2016. So it went into effect 20 days after that publication in the EU Official Journal in May 2016 and will be directly applicable to all member states 2 years after that date. So obviously that date is coming up this year in May of 2018, the 25th of May 2018 to be exact. At which time organizations who aren't following might face heavy fines, or if you've had a problem or a data breach or something like that. I don't know that anybody can say you're guaranteed any kind of fines or anything right now, but there may be things that various regulation bodies begin looking at. So now, before I go on, alarm from my computer there, sorry about that. Before I go on, I really want to kind of discuss quickly the word compliance in the terms of these new regulations. Often in the security industry you hear words compliance or certificate of compliance, and some security standards out there have specific requirement and testing procedures clearly defined that set at least a low bar for meeting a specific requirement. An example might be the payment card industry data security standard, You can be audited as an entity and your procedures tested and evidence gathered to prove that you are compliant to that specific standard. And obviously then, if you are found compliant, you get an attestation of compliance that's signed and provided by the company or the auditor who did the assessment. Now, laws and regulations like GDPR, HIPAA, etc. are not in all cases easy to interpret. So this is different than a specific standard with exacting requirements and exacting testing procedures. I want to make sure we're clear on that. There are some things in GDPR that are pretty easy and obvious to interpret. For example, GDPR states that you have to have an opt-in choice for a data subject, from a data subject, before you can store, process, or transmit their personal information. That's pretty clear, and you could probably determine that as met or not met, something that's fairly obvious there, built right into the regulation or the law. But others are more difficult to interpret. For example, the comment in GDPR that says, protect your data by design and default. So how do you say that you're perfectly compliant, or meeting an exacting standard to that, really? It's subjective. There is no standard to compare with. So my point is, be informed, be wary, be reasonable. It's basically impossible to say with absolute clarity and that an entity is 100% compliant to GDPR or provides a certificate of compliance, because there is no specific standard with testing procedures defined. Perhaps that will come later in the industry. I know that there are various supervisory authorities that are working on all kinds of different, checklists and things like that. So that as time goes on, there may be more public audit protocols that will be published. Then words like, specific words like compliance and certificates may be able to be used, but at this time that's a difficult one. So as you are addressing your GDPR effort and meeting the requirements that are defined therein, make sure that you're understanding that, you're being wary, and you're avoiding people or companies that promise compliance or promise a certificate. You can be addressing GDPR regulations very carefully, documenting your results, making plans, following plans, showing risk analysis results that are giving you confidence that you're following the principles in the GDPR. It will also provide confidence to any other regulatory body that may ask for proof that you are following these requirements. So anyway, that was kind of a long discussion there, but I wanted to make sure that we got that clear. So GDPR, why should I care? Now, people like to use scare tactics out there in the industry, and this is probably a pretty good one. They're saying people who are not following the GDPR guidelines can be fined up to 20 million pounds, or euros actually, 20 million euros, or 4% of their annual global turnover. Revenue is a term often used here in the United States for the preceding financial year, whichever is greater. Now, that's a maximum fine, right? And there's no necessarily any kind of guidelines that say this will be it. It might be, less. It may not even be at all. So, there are potential penalties. We're not saying that the sky is falling. You just need to be informed about possible results. It helps you and your companies in planning and understanding what your risk tolerance is and understanding the plans that you may want to make. Notice, though, there is also a tiered approach to fines. For example, you might not be fined 4%, maybe you're fined 2% if you don't have records in order per Article 28 of the GDPR, or not notifying the supervisory authority and data subject about a breach, or whatever. There might, or maybe not conducting an impact assessment, smaller pieces of the GDPR. You might only be, fined a smaller amount. However, it's important to note that these rules are applying both to controllers of data, or people who supply information, or processors, meaning people who may take information from other entities to then process and return back results or whatever. It also kind of helps us understand that kind of the cloud services will not really be exempt from GDPR enforcement. Just as kind of an example, in January of this year, recently there was a data breach example. The this is one specifically in the UK. Maybe many of you have read about it. There was a company that lost a bunch of data, 3 million customer records, but it was clear back in 2015. That company, Carphone Warehouse, was fined £400,000, $552,000 US, and assessed just January the 10th by the Information Commissioner's Office, the ICO in the UK. So I'm guessing most likely that is they're being fined under the EU Data Protection Directive. I haven't really found that. However, to get that kind of fine, there had to be some pretty obvious bad practices in security. There's a quote by Elizabeth Denham, Information Commissioner there in the UK, stating, "A company as large, well-resourced and established as Carphone Warehouse should have been actively assessing its data security systems and ensuring systems were robust and not vulnerable to such attacks. Carphone Warehouse should be at the top of the game when it comes to cybersecurity, and it's concerning that the systematic failures we found related to rudimentary commonplace measures." So there were things obvious that were pretty obvious there. It wasn't like some little thing one little teeny thing they were doing wrong. They were doing some pretty major things wrong. So again, it has to be something that is dangerous to data. So when do I have to worry about GDPR? As we mentioned before, it was approved in April of 2016, so you have till May of 25th, 2018 to begin complying with these regulations and following them. Right now we don't know. Nobody will know who they're going to go, who anybody will go after. Any of these supervisory authorities will go after, how aggressively they'll go. But after May 25th of this year, they possibly can go after organizations. Recent blogs by the UK's Information Commissioner Elizabeth Denham has really, as I've read those, it gives us some feelings of at least one supervisory authority's point of view on what will happen. You can go to their website and to their blog and look at some of these. I really have enjoyed some of her statements. She sounds very reasonable, very understanding, and if you're messing up really bad, then you should get in trouble. If you are doing your best and moving towards compliance, moving towards, there again that word, it's hard not to use that word when you talk about it, moving towards meeting these requirements is there. I don't really feel like specifically that office is out to get anyone or make big examples of a company. My take is that the upcoming GDPR deadline is not an end of the world. It's not a Y2K kind of a thing. I think at times we all get caught up when a line is drawn in the sand and we fear the worst. People need to do business with and with PII, and you may also, other people that you do business with may get caught up in this feeling, and we need to help them understand that businesses should be progressing forward and not backward or being stagnant when it comes to GDPR. So the upcoming GDPR deadline in my mind might be interpreted as you've not interpreted, or it could be interpreted as, many people right now might say, you fail, you pay. However, I think it can be more like, okay, let it be known that on this date we all agree that GDPR requirements are in place. You need to work on them in a proactive manner. After thinking a lot about it, I believe that I lean more towards that second interpretation as a little bit more likely, rather than we're calling you on May 26th and saying that you fail and therefore you have a fine. Being in kind of an audit or legal department does make us want to think in absolutes when giving advice to a company. It's our job. So definitely you should be serious in working on it in a proactive way. However, many of you will most likely have issues to resolve even on May the 25th. Some of these issues may even take a little bit of time to finish. Businesses have known about this for 2 years, about this change, so it's serious, and the regulation will begin on the 25th. However, I think being able to show your company is moving forward is very important, especially if you have a data breach after May the 25th. So if you do that, and if you do have a data breach and can't show proactive work on GDPR regulation following, then enforcement of the regulation probably could go much harder. All right, enough long-winded stuff. I want to kind of quickly go through some terms that are in use in the GDPR and that you may hear out there in the industry. Data controller is an entity that determines the purpose and means for which PII is processed. So that's somebody who's saying, I would like this information, I need to get it. A processor might be somebody then who processes personal data on behalf of a controller. Supervisory authorities are those independent public authorities established by a member state in the EU to represent the people and oversee and monitor businesses as they are working with entities' personal information. Another term that you hear in the GDPR is pseudonymization. Now that's a process that's transforming personal data in such a way that resulting data can't be attributed to a data subject without use of other information. Things like encryption and data separation can do that. It's an odd term. Personal data that has been pseudonymized or key-coded can fall within the scope of GDPR depending on how difficult it is to attribute the pseudonym to a particular individual. Any personal data which is defined as information relating to an identified or identifiable natural person, data subject, falls within the scope of the GDPR regulation. However, it may not apply to data that does not relate to an identifiable or identifiable natural person or to data rendered anonymous in such a way that the data subject is no longer identifiable. Note that anonymous data is different than pseudonymous data. It's kind of a weird thing there. Pseudonymous data can be data being protected using something like encryption or hashing or tokenization algorithms, or it may be removing or obscuring direct identifiers and holding them in separate, distinct databases that can only be rematched using a key of some sort. You know, it sounds kind of complex. However, I think a lot of people may think, well, if I can just do that, then I'm totally out and I don't have to do anything. The use of pseudonymization may not get data out of scope for GDPR, but it does allow the relaxing of some provisions for using personal data for secondary purposes, for example, scientific or historical research. It also may help with meeting the regulations' data security by design requirements. So, the fancy word pseudonymization there, you may be able to apply those principles to make your life a little easier, but it is not a silver bullet that gets you out of GDPR. I think we all kind of know what a data breach is. If you lose unlawfully, accidentally or unlawfully destroy, alter, or some other way disclose or provide access to personal data that's being stored, processed, or transmitted. So that's kind of what a breach would be. So we talked a little bit quickly about who enforces GDPR. These supervisory authorities, there's supposed to be one being identified in each country or the countries in the EU that have signed up for GDPR. For example, the Information Officer's Commissioner's Office in the UK would probably be an example of an SA. It would be a good idea to start identifying who your SA or SAs are. And the SAs then are the ones that would be responsible for issuing fines. And note, the GDPR does not say anywhere that fines are independently cumulative. It's assumed that the maximums are maximum across all of the entities in SAs. In other words, if you did something really horrible and lost millions and millions and millions of records and it was totally negligence on your part, perhaps they would go to the maximum of 4% or the 20 million euros. But you're not going to get 20 million euros from every different EU SA. So let's talk about some international concerns. I know that there's a lot of people here on that webinar today from the United States. So discovering who your SAs are is currently kind of a hard part. GDPR, the way it's written, doesn't require you to deal with every single SA in every member state that you work with. there is a provision for an entity to select a lead supervisory authority. That's Article 29 of the GDPR. So if you're a company that's entirely incorporated inside the EU, you work only in the EU, and you deal with people within the EU, other countries and other companies then that are incorporated there, then wherever your main place of business is probably where you would say that's my supervisory authority. If I was in the UK, perhaps that would be the ICO office there. If I was in Germany, perhaps it would be the supervisor authority there. You may still do business with Germany if you're in the UK, or the UK if you're in Germany, but the lead supervisory authority would be the one that you would deal with for all kinds of issues. You wouldn't have to be dealing with all of them. So let's see, what are things that are not covered here? So it's important that you then select and document the lead supervisory authority. And like I said, for companies that have a major presence in the EU, you can select a single one. Now, let's talk about US companies just for a second. If a US company has a physical presence in an EU company or in the EU country, then you can say you have an establishment or a place of business in the EU. Then you could select a lead supervisory authority that would be that company. It's a very detailed process, and you need to make sure that there's a whole, like I said, there's a whole Article 29 Data Protection Working Party. You can look it up there. It's linked in many of the websites to look up this process. Now, if you're a U.S. company or a company that's outside of the EU that does not have an established presence or an establishment in the EU, this GDPR cooperation and consistency mechanism that we've talked about only applies to controllers with that establishment within the EU. If a company does not have an establishment in the EU, the mere presence of a representative in a member state, like one person, may not trigger the one-stop shopping kind of system. It probably means that controllers without any establishment in the EU must deal with all the local supervisory authorities in every member state that they are active in through that process. So think about how it applies to your company. So obviously it can be quite complex. You may have to deal with a whole bunch of them, or it can be very simple. You may only have to deal with one SA if you have a presence in the EU. So kind of with all of that background, what do I do now? Well, obviously an important thing to do is to learn about the GDPR requirements. We appreciate you being here today. Again, this is not a know-all, end-all webinar about everything GDPR, but we're just giving you some ideas here. There are some great websites out there to learn about it. I have really enjoyed the information on the ICO website, ico.org.uk. I'll put that down here in the corner. I think that's a really nice summary if you'd like to go there. And there's a link on their first page that gets you down to the GDPR information. So start working on it, start understanding it, start reading about it, start figuring out what things you don't have in place. There are many checklists and services out there available. SecurityMetrics is also working on one that you can potentially use here soon. And start finding things that you need to fix and start fixing them. You also need to think about all the documentation that may be required. Perhaps there's a whole lot more things that need to be written down and processes documented that really isn't there. You need to either create all that or maybe find people who have packages of these documentation that you can modify. Documentation will be a pretty big task for meeting GDPR regulations. So how does GDPR kind of match up with just general data security? Like I said, I've been working in this industry for a lot of years, and data security is data security. You should have a firewall. You should be good at watching out for viruses. You should update your systems. There are certain things you should do. You should have controls and policies and procedures over who can get the data, who has access to the data. There are those elements that are common in all of these security kind of regulations or standards. So GDPR does encompass some basic data protection principles, basically in one statement that they make in the GDPR there, that we'll talk about a little bit later here. And does that mean that if you're compliant in other publicly regulated data security initiatives like PCI DSS, or in the US the SOC Type 1 or Type 2, or if you're in ISO 27000 or 27001, are you doing some of those things? Then yeah, you may have some controls around data security that can already be in place. And I'm assuming that's kind of what a lot of people, when they answered in the poll, that yeah, I'm kind of sort of ready, and you may already be in areas that you've got data protection. The thing about it that's different, for example, if you're a PCI DSS kind of person, GDPR may require additional scope, because maybe now you have to think not about just one type of data, but personal information can be much larger. Boy, defining personal information is one of the hard parts, and actually kind of a fuzzy part in this GDPR as well. Like, how can you really determine an individual from a certain piece of data that you have? That's something that all companies have got to kind of go through and think about. So specifically, let's say PCI DSS versus GDPR. If you're PCI DSS compliant, are you totally done with GDPR? No. There might be some data security crossovers, some things that you're doing may be there, like I mentioned before. So the biggest difference between these two regulations is PCI DSS is focused on card data, while GDPR focuses on personal data of any kind, names, addresses, phone numbers. So if your personal data that you handle is exactly and only card data, then the scope would be very similar, or maybe exact, and you may be a long way towards GDPR security requirements. So it really kind of depends. While PCI DSS may not be directly relatable to GDPR, it can help in some of those obligations and implementing technical measures to protect against the data breaches. PCI DSS, for example, is pretty deep in data security specifics, firewalls, all kinds of different regulations on antivirus or on coding practices, etc., etc. GDPR is more in depth than other things like processes for notification and privacy issues and the ability to delete data, things like that. But they all imply data security. So let's go into some just GDPR requirements background. One of the main things, frankly, in any kind of a security effort, a data security effort, the first thing you really need to do is discover and clearly document where all of the data that you're trying to secure is, where it flows in and out of your organization, inside your organization, etc. So, it's amazing how many places personal information can get to, and when you do the detailed analysis of what kind of data you get and from where, it's like Jurassic Park. Is that what it was called? Jurassic Park. The video or the movie where all of the dinosaurs weren't supposed to be able to get out of this area and weren't supposed to be able to reproduce, yet they did anyway. That's kind of like sensitive data. It just gets places where it's not supposed to be. So the hard part is finding it under what tree or under what eddy or whatever, in what computer or cabinet or warehouse or wherever this data is residing, and mapping that. It's a basic principle of all security efforts. You can't protect what you don't know is there. So this process consists of assigning a person or a group that has been enabled and empowered of going through all the departments, groups in a company and searching for PII or personal information with various types of tools. You can use regular expression search tools. We have one called PyScan. All kinds of different things that you can use there. Interviews, reviewing documents, mapping software data flow, using talking to the development guys, etc. So once you know where all of that data is and what you get and where it flows, it's critical to document this information in the form of network diagrams, data flow diagrams, process descriptions, and often people are quite surprised at how much data they have and where it is used and by what groups in a company. So that's the same for any kind of security. This is one of the main things right at the very top of kind of GDPR that you need to start doing. And that's something you can start doing today, and really just figuring it out and making progress. You can make progress today by starting those diagrams and starting those discussions in your companies. Communicating privacy information, privacy notices. As I mentioned, GDPR has a lot of the same core principles on communicating with those that you obtain PII from, but these core principles are quite extensive in this regulation, and it can be provided directly to an individual who's giving you their PII or to an entity that provides PII to you that has been previously collected. So these principles center around clear communication to data owners on what data you're getting, why you need it, how it's going to be treated, and this communication is required to be very transparent and easy to understand and to find on websites or in documentation for any of your customers. And this communication really needs to explain things such as, what is my lawful basis? Why are you getting my data, and why is it, why do you need it? What's the lawful basis? How long will you keep it? What are your rights regarding the data? What are the data subject's rights regarding the data that you are processing and storing for them? So having clear communications, processes, documentation, website notices, all kinds of things like that are going to be very important for GDPR regulation. A little bit kind of a detail more on individuals' rights, these data owners. So this isn't going to be all the rights that are documented in GDPR, but kind of a few of them. So there's this right to portability. So the users may want to request a copy of their personal data in a portable file format that can be transferred to another entity. Is that just, hey, a download into a CSV file? That's something that you're going to have to think about as a company. If somebody wants to move from your company to another company that does exactly the same thing, how closely do you have to provide data to them to move it around? The right to erasure. Data subjects have the right to request that their data be deleted. Now, I've read recently on this because this is a tough topic out there in GDPR and one that's still under a lot of debate, and people are trying to figure this out. It doesn't necessarily mean the right to absolutely forgetting for all time with no traces whatsoever. It means, hey, if it's possible, if it's something that can be done that makes sense, and I don't need it for defending myself legally, blah blah blah, all kinds of things. We don't have time to go into all of the ins and outs of that. Again, the ICO website has some really great text and wording and guidance on all of these individual rights. I recommend that you go there, the ico.org.uk, click into their stuff and start reading about this stuff. That's another thing you can start doing today, right? Really trying to understand and think about what things you are going to need to be putting in place. The right to object, saying, hey, I want to opt out, and maybe of direct marketing. I object to receiving emails from you. This is an interesting one too, because what if you say, if somebody says to you, I want to be erased, I want you to forget me, and then what if you happen to get their name and email or whatever from a different source, and unless you kept what their data was the first, you can't know to compare. There's all kinds of really weird things that get into this. Don't take this as setting policy or setting actual requirements. These are just some of the things that we here at SecurityMetrics and regarding our GDPR compliance effort are trying to deal with and figure out. So it's something that even the security guys are having to deal with. And how do you interpret this? And so how do I say that I've forgotten somebody and won't ever email them again if I don't keep something about them that tells me to watch for them. So it's a really interesting thing. There's some pretty obvious ones. Don't profile people, right? Somebody should be able to say, hey, look, I think you're profiling me. I want you to quit that, or for marketing purposes, you must require explicit consent, those kind of things. Do some more research on that. So again, we haven't gotten into everything here. The action that you have is to document how you would do some of these things, or how you would provide this data electronically. How long might it take, and when does it become very hard to do, and etc. And that's where these subject access requests come in. In the old regulation at the EU, it was from 40. You could take up to 40 days to provide a subject with data access. He requests his data from you. Now it's down to 30 days. Now, if you had a huge amount of data, and these access requests are typically pretty hard or difficult or time-consuming as you search through databases, etc. You can say, I need more time than that, but you have to be able to justify it. So you also have to provide this data pretty much free of charge, unless, again, it becomes manifestly unfounded or excessive. If you refuse a request, you have to tell the individual why, and that they have the right to complain to the supervisory authority, but you must do this without undue delay and at least within 1 month. So there's all kinds of really subtle details to this law. And again, I think if I were you out there, I'd start with some of the interpretations of it rather than going directly to the regulation. The regulation itself reads like a law, and it's hard to understand. So again, things like the ICO website, I think, have been really great for helping me understand that. Basically, you need to be able to have documentation and explain your company's need to obtain personal information. It needs to be obviously legal, and document it, and then make that documentation available to individuals whose data you gather. So, you have to have a good reason for getting this data. Consent is another thing that is part of the GDPR. Consent must be obtained from individuals before you begin processing, storing, or transmitting their personal data. So that's basically kind of an opt-in type of a process. It can't be an automatic take data and do a quick pop-up to inform them that you have something on your website somewhere that says that if you enter data here, you consent. It's like inferring consent. It has to be a physical opt-in. So make sure your process considers this and makes modifications as necessary to make it a clear opt-in choice by individuals. Record that choice in logs. This choice can't be slipped into a big terms and conditions statement. It needs to be separate. So make sure you have clear and concise privacy documentation available to, all individuals. Consent for children is something that's mentioned specifically. Not that it's a whole lot different, other than if it's a big part of your business, they make some statements about these privacy notices have to be written in simple language that children will understand. I think there's a whole lot more detail in the law about this. We won't get into it, but the hard part here is what age, and how do I write this? And obviously, if a child can't read, then somebody else has to, read it. The parent has to read it and understand it. So, you can see here some of the things. It's over 16 years, and or no, is that less than under 16 years? You've got to get parental consent, and in the UK it might be less than 13 years. So, reporting breaches, and if you detect a breach, you've got to take care of it. So that means you've got to report it. You've got to have policies and procedures to be able to detect it, investigate it. You have to have an incident response plan. You've got to report these personal data breaches to your supervisory authority or lead supervisory authority within 72 hours after awareness of the breach. And that's where a lot of problems in a lot of these security rules get in, is that people will know that they've been breached and they don't do anything about it, or they try to cover it up or whatever. So just don't go there. And obviously, if individuals are facing adverse impact you got to contact the individuals directly. For example, the pseudonymization that we talked about earlier may be able to mitigate this if all of your data was encrypted and that's all they got, and it was very hard or almost impossible for them to turn the encrypted data back into PII. Then you can say, well, I don't need to inform all of those people. Data protection officers. There's a provision in the regulations that say that you should have a data protection officer if you're a certain type of a company. Typically, there are public authorities or bodies, really large systematic monitoring of huge amounts of people on a large scale. Maybe there's health records or large amounts of personal data for various types of items that you're collecting, convictions, offenses, whatever, all kinds of things like that. You may want to say, hey, this is a big enough deal. We have so much stuff. We need to have a data protection officer defined. And there are some rules about who that person can report to and what some of their roles are. Even if you don't fall into one of these big company categories, we highly recommend appointing either a person or a group as a data protection officer, or at least a committee or something. But it's very important that DPO needs to have knowledge, support, and authority to carry out his role effectively. Things get a little bit murkier in the U.S. here for companies without a physical presence in the EU. According to some sources, GDPR addresses this issue by requiring companies without an establishment in the EU to designate a representative located in the EU. Again, I think this is you read some of these things and you go, oh my gosh, what am I going to do? You may want to just, don't freak out and just go, let's figure out what this is. Let's wait for the law to be defined a little bit more, etc. The best thing you can do is start working on the things that you have direct control over. I don't think that this means run out and hire somebody in the UK just because you can say that, you have to do this. So react with reasonableness. So this one right here, data protection by design. They make this statement. Data protection by design and default is a legal requirement in GDPR. And to me, that's kind of an understatement. I think it reminds me of the Star Wars movie when Anakin said to Obi-Wan, why else do you think we were assigned to her if not to find the killer? Protection for our job is a job for local security, not the Jedi. It's overkill, Master. Investigation is implied in our mandate. So likewise, this statement has a whole lot of stuff that's implied by this quick statement. Implementation of effective data security measures applied to your systems and processes is implied in that data protection by design statement. Security is an implied mandate. This one statement itself can create a myriad of other data protection and security requirements that are not specifically defined by the GDPR law. Again, I mentioned this right at the very beginning, but are well known to the data security industry. So you may be familiar with many of them, as we said, if you're undergoing PCI DSS or ISO or SOC or other security assessments. So use things like the data protection impact assessment, or that's like a risk assessment, an ISO risk assessment process to figure out what's critical and design and implementation. So we're going to talk about that a little bit more on the next slide. These data protection impact assessments need to be conducted when specific risks might affect the rights and freedoms of data subjects. Like things like if a new technology is being deployed, you need to do another one. Obviously, you should do it at the beginning as you're starting this. If a profile operation is lightly impacting individuals, you need to do that. There's going to be a large-scale processing of special categories of data. You need to make sure that you're doing one of those. Like I said, it's just the same almost process as is defined in the ISO 800-30. It's a risk assessment that we use to gather information from your data mapping exercise. Security considerations. We're getting down close here to the end. Again, that one statement implies a lot of things. Here are things that we here at SecurityMetrics know. When we do forensics, we have a forensics division that does investigations after the breach. Here are some of the main things that are causes of breach. Number one, remote access security. It's insecure remote access. That's a data protection by design thing. You should have this in place. You should do web application security design. You should have good edge firewall security. You should be doing external vulnerability scans to check your outdoor, if all your doors are locked, nobody can see in the windows essentially of your websites and other systems. Wireless network, password policies, malware prevention, physical security, all these things. On top of that, there are some other best practices. You should be getting a penetration test. You should do encryption or pseudonymization of data. You should do file integrity monitoring, security training, patching, internal vulnerability scans. I mean, the lists go on and on. These are things that, in my mind, are implied by that one simple statement in the GDPR. So what are our quick takeaways? Start working on privacy and disclosure documents. Start reading about the law. Do some data mapping as soon as you can. Performing risk analysis and gap assessments are going to be important in your business. And those are the things that you would want to focus on. Many companies do this sort of thing. SecurityMetrics also does this kind of stuff. Process large amounts of data. Make sure that you are thinking about what would I have to do to see how close I am to following some of these requirements. Don't ignore this law. We're available for questions. Just so you know, I mean, like I mentioned a couple of times during here, SecurityMetrics will have some GDPR kind of early bird, some things that you can see on our website, and some early bird pricing on that if you'd like to go through some of those early adopter tools. Again, this isn't going to be like a full on you're totally ready, but more what do you need to do to get ready. This time I think we have just a few minutes to take some questions, and I'm happy to do that at this time.
Yeah, thanks, Gary. That was a great webinar. Covered a broad range of topics there. We had several questions come in. So what we'll do now is we'll try to address some of the questions that are kind of more broad and apply to the largest amount of people here in attendance today. We probably will go a few minutes over past the hour here, so you're welcome to stay on if you have a little bit of extra time. If not, again, this is being recorded and we will send this recording out to you. So one question that we had come in a few times during the webinar is a little bit of clarification on who the GDPR is directed to. Is it just to the EU community? Is it more global? And specifically to the UK, as a result of Brexit, does this still apply to the UK?
So here's what I know about that, and we talked about it just a little bit briefly early on, and that is GDPR is directed towards data of EU subjects. And so if you are a company that gets data that may contain individual personal information about somebody who is in the EU, whether you are in the EU or not, this law applies to you. So if you're in the United States and you are getting data from people in the EU, then it applies to you. If you're in Brazil and you're getting data from people in the EU, it applies to you. So it doesn't matter what country it is, globally applicable. It's just, hey, they're saying this is our data, this is the data of the EU, people here, we want our data to be handled well, and that's what it's kind of applying to. As far as Brexit goes, I know that what we've learned is that if they get out, when they get out, I don't really, being from the United States, sorry, I probably should know more about this, but the UK will have something either identical or very similar to GDPR. I don't know if it will be called that. I would assume that it's going to be identical. It's going to be the same thing. The ICO office there in the UK will be the ones that are going to be managing that. So it's probably no change. I don't know what the subtleties might be for international interaction in the EU, in the UK's version of GDPR when all that happens. But I wouldn't, at this point, worry about it. I would just say, let's just consider that it's all the same.
Great. Another question that we had come up a few times is kind of relating to small businesses. How does the GDPR impact small businesses, especially for those with minimal credit card transactions?
Small businesses have smaller risk. I guess it's the same as with any data security law. I mean, PCI is the same. Small businesses are required to do less as far as validation goes in that space. You don't have to have an on-site auditor. You don't have to do all this kind of stuff. However, it still applies to you. And if you are negligent and lose data, even if it's a small amount, there is a potential that you may, be found out, I guess. I mean, part of this whole thing is still, if my data is lost and it's being used and it's discovered by an SA or reported to an SA, then regardless of your company size, you're going to be subject to these laws. So you better have some sort of preparation and defense. I don't think it really matters. There might be less things. Maybe you do try to do more stuff on your own, or maybe you work with a company that can help you out. That's up to you.
Great. Another question that we had come in, we had quite a few people asking about the right to erasure, and just a little further clarification on that. For example, how does it impact organizations that are required to keep information for a certain amount of time? And also how to interpret for cloud-based services.
So the first part of that question is for people who have, there is a provision in the erasure area that says, yeah, you may need to defend yourself legally, and so you can't, if somebody says, for example, let's say I'm a forensics company, and somebody says, I don't want you to keep any of my data that was lost in this forensics thing, for whatever reason. Somebody would say, I'm going to contact this company and say, I want my data erased. You can say, well, sorry, we need this for an ongoing legal investigation, so no, I won't. So yeah, there are different things that can be reasonable and accepted exceptions to saying erase me and all of my traces. For example, here at SecurityMetrics, we have to keep security records of audits that we do for 3 years. It's just part of something that we're required to do by a number of entities. So we do that, and we wouldn't erase it even if somebody asked us to, because we're being required by another entity to keep it. So those kind of things you could, as long as you can defend it, you're going to be fine. And that's, again, part of a lot of this is, don't just ignore it. Think about how you're going to defend it. And they're reasonable people, I think, in these organizations, as far as I understand. Okay, next question.
Great.
Did I answer both of those?
Yeah, the other half of that was how to interpret for cloud-based services.
Oh, I don't know that I would interpret it any differently for cloud-based services. Either your computer is in a cloud or your computer is not in a cloud, or you're contracting with a company like Salesforce or others, right, to store data for you. You may need to address that with them and talk to them and say, how are you helping me make sure that the data that I send to you is secure? So in that part, again, GDPR has parts where it says you've got to go outward a little bit and make sure that you're making correct decisions. I wouldn't go with, Steve's local contact list. If he doesn't really care or want to do anything about data security, you'd want to go with somebody who understands some of these regulations.
Awesome. All right, so we have time for just a couple more questions here. We did have several people answer that they're also complying with the PCI DSS. And if we could briefly kind of go over that again. For those that are PCI compliant, what is the level of effort required to comply with the GDPR? Are payment card details protected under GDPR? And just a little bit more clarification on that.
So absolutely, payment card information is protected under GDPR. It's parts of that data are personally identifiable, obviously. So is it in scope? Yes. If you're already PCI DSS compliant, and like I said when I talked about this before, if the data that you are, if you're a small store or whatever, and the only personal data, PII data that you're getting is in the form of credit card information, names, name, address, whatever that comes with the on the chip or in the swipe, or typed in or whatever, then your scope may be identical. So security guidelines, you need to feel really good about it if you're compliant. Then you've done well. There may be other things like opt-in and data privacy notification, documentation, and process. Kind of the first part of the GDPR has a lot of documentation, a lot of process. The last part, which says do data protection by design, is really the PCI part, right? There may be some things, you may have security policies and procedures in place for security and PCI DSS that would be helpful in GDPR, but it's not going to be all of it. So is the work less? Indeed it is. Can I give a percentage? I really don't know. It depends on, do you take those names and addresses and send them to a marketing group? And does the marketing group do something different with them? Do you send information to a sales group that then does more stuff? I don't know. That's going to be your decision, but be careful about scope when you're using any part of your PCI data and sending it other places.
All right. So one more question here. A few people would like a little more clarification on breach notification.
Notify of breaches. I don't know, we probably don't have a lot of time to go into that, other than you got 72 hours to notify your supervisory authority, or if you are a U.S. company and don't have a presence in the EU, then you've got to, I would assume you have to inform all supervisory authorities of people who data you may have. So that could be a pretty big task. So as far as incident response and breach, boy, if you're worried about it, then make sure you have an incident response procedure well documented, written down. You know who to call, when to call, who's going to be responsible to call. Have a little book they open up where they can just go through the steps and don't have to run around going, what do we do, what do we do? Know exactly what you should do, kind of practice it in your minds, think it out, and do your best to report. And it's always better to report than to hide, is what I found. It's a lot less money exchanges hands in that way.
And as far as the timeline for processors and controllers, so is it 72 hours from when a processor tells the controller?
It says as soon as you're aware.
Okay.
As soon as you're aware of a breach, you got 72 hours.
Okay, great.
So whether, if you are a processor, as soon as you're aware, if you're a processor, you have SAs, and if you're a processor for a controller, then yeah, I would let the controller know within the same amount of time. And if you're a controller and know that one of your processors has a problem, then there might be two pathways. And this might be getting reported by two different entities, a controller and a processor.
Great. All right, well, I think that's all the time we have today for questions. Again, apologies if we did not get to your individual question during this webinar, but again, if you did chat in a question to us today, we will be reaching out to you on an individual basis. Thanks everyone for your attendance today, and we'll look forward to seeing you in our next webinar.